Hello, I'm Lewis Gordon. I've been a lawyer in the U.S. for 35 years, and I'm the executive director of the Environmental Defender Law Center, a nonprofit organization that I founded in 2003 to help protect the human rights of people in developing countries who are fighting against harm to their environment. EDLC has now worked in 60 countries. We find lawyers, also expert witnesses for cases. We prepare and research legal briefs, friend of the court briefs on international law and especially human rights law and comparative law. We advise communities. We provide grants. We focus on cases against multinational corporations, especially mining companies. And in part, this was because in my previous work as a private attorney, I specialized in this area, in particular, working for many years on representing the plaintiffs in the Exxon Valdez oil spill case from Alaska. I'll be talking today about transnational lawsuits and, to some degree, domestic lawsuits against mining companies. And these cases tend to fall into three categories. First, cases in which the goal is to try to stop or prevent a mining project from going forward. Second type of case is one in which civil and political rights, human rights violations arise in connection with opposition to those projects. And third, cases that seek compensation for harms resulting from those projects, often harms to human health and to the environment. In particular, I'm going to focus on transnational cases, but in the first area, for stopping projects, there are definite limits to using transnational litigation as a tool. Transnational cases are typically cases seeking damages, not injunctive relief, such as trying to stop a project, having a court order the halt to a project. For a court to make such an order would involve the issue of sovereignty of foreign nations to put forward projects of their own, and courts understandably in one country feel reluctant and unable to do that because of the active state doctrine and other legal doctrines. Also, these cases tend to raise questions of land ownership, which is often at dispute, and for a court to decide questions of title to land in a country other than their own is typically barred, often under what's called the Mozambique rule or similar legal doctrines. So therefore, if the decision is to challenge a project in a domestic court instead, such as in the Philippines, which is quite frankly the usual approach to trying to stop projects, I would mention that groups like EDLC, my organization, can provide different forms of support for these cases too, such as the briefs that I mentioned, which have led to, in part, to successful results in cases in countries like Colombia, Mexico, and Chile, where cases have been focused on free, prior, and informed consent, right to culture, right to a healthy environment, and foreign groups like ours have weighed in on behalf of communities in those challenges, which again have sometimes been successful. As I mentioned before, we also provide grants, which would be for domestic litigation as well, and sometimes international firms will advocate on behalf of affected communities. And finally, it is often possible to obtain scientific help, expert help for review of mining projects, evaluations of environmental impact assessments, all to help communities understand and point out harms from mining projects. Turning to the second and third types of cases, I'd like to combine these two topics because the legal and practical issues are similar, and those two topics, again, are remedies for civil and political rights violations and remedies for health and environmental harms. Again, I'm going to, at least for the moment, talk about domestic legal proceedings. These cases are, of course, typically involving civil and political rights violations in a defensive position, defending against criminal cases defamation cases and SLAPP suits in general. And I would mention that we can help with legal briefs, especially on SLAPPs, as we've worked extensively on these issues, including in the Philippines, as well as through advocacy for dismissal of charges against activists who are being persecuted because of their opposition to mining projects, and sometimes even seeking asylum, political asylum in other countries when the situation just gets too difficult. Now, domestic cases seeking compensation for health harms and environmental harms, the final category, those cases are not commonly brought in domestic courts, but increasingly they are being brought there, and that option is definitely worth considering. We regularly find experts and lawyers and provide grants for such litigation, and later on I'll talk about why one might prefer that route rather than a transnational case, even assuming, of course, a transnational company might not be the proponent of the project, which would give you no choice but to file domestically. So let's get to the heart of this area, transnational cases against mining companies seeking compensation. And I'd like to, before turning to some specific examples, I'd like to talk about some issues in common to all these cases, some really critical issues. As I mentioned before, in terms of the remedy, typically these are compensation cases. They're brought in tort for harms to individuals or harms to health, negligence, nuisance, sometimes strict liability claims. And the clients in these cases, the plaintiffs, are usually individuals, although sometimes they can be entire communities. In terms of who are the defendants, of course, in a transnational case, the defendant is typically the parent company of the company that is causing the harm locally in a developing country. And sometimes the subsidiary company, if there is one involved, is joined as well as a defendant. A key issue in deciding whether a transnational case can be brought at all is where is the parent company located, and thus where will the case be brought. This is extremely important because depending on where that parent company is located, a case simply may or may not be feasible. And the reason for this is the doctrine in Latin, forum non conveniens, otherwise known as the inconvenient forum rule, which gives a court discretion to dismiss a case and send it back to the country of origin if, in the court's opinion, it's more properly brought in that country where the harm arises. And this, when it comes to cases involving U.S. companies, this is really a deal breaker. Literally 95% of the time or more, when U.S. courts are dealing with cases filed in the U.S. for these types of harms overseas. I'm not talking about alien tort claims cases, which are a very limited category that I won't be discussing today, and quite frankly are much more difficult to bring following the Cayo-Bell decision by the U.S. Supreme Court. But in 95% of the cases, the U.S. court will say this case more properly belongs in Peru, the Philippines, Colombia, wherever the harm occurred. And that's the end of the case, at least as far as bringing it in the U.S. goes. In Europe, it's a very different story, and for this reason, we focus our efforts on cases involving European companies. This doctrine, the inconvenient forum doctrine, is simply not available against not available to parent companies domiciled in European countries who seek to have the case not be heard in Europe. So if you file the case against the parent company in Europe, it sticks. You may not win the case, but you won't be thrown out for this reason. In Australia and Canada, the answer is somewhere in between. Not as many cases filed in those countries against their companies. The rules are not as bad as in the US, not as good as in Europe. And finally, if the case involves a company domiciled in yet another country that I haven't talked about, such as China or other countries, very difficult to bring a case there. The next common issue in these cases is that of parent-subsidiary liability. Typically, as you well know, mining operations are conducted by subsidiaries of multinationals rather than the multinational itself. And those companies are typically domestic companies. A Philippine company, for example, owned by a parent company in another country, perhaps. As a result, if you sue the parent company in another country, the country where it's domiciled, the company will typically argue you're suing the wrong company. You don't have jurisdiction over our Philippine subsidiary because it's not a French or German or English company. And while you have jurisdiction over us, we're no more responsible for these harms than, let's say, any other shareholder of that company. Now, we all know that's not true, but legally it can be a complete defense. In the old days, so to speak, the way we would proceed in those cases is to try to pierce the corporate veil and hold the parent company responsible for the acts of the subsidiary. That's very difficult to do, and in a growing number of jurisdictions, courts have allowed cases to proceed on what's called a direct negligence theory against a parent company, that the parent itself was negligent in how it treated the victims in the foreign country, sometimes under an agency theory. In any event, new alternative theories that are not as difficult to try to hold the parent company liable. Nonetheless, this, along with the inconvenient forum rule, is the big obstacle to bringing transnational cases. In terms of the substantive law that's applied in these transnational cases, to generalize, it's the law of the country where the harm took place rather than the substantive law of the country where the multinational is domiciled. This can create some logistical problems because one must first educate the court, typically through expert witnesses, as to the content of the substantive law of that country, and it makes for two battles. The first over what does the law of that country say, and the second battle over on the merits of the case. Who are the lawyers who bring these cases, and how are they found? We're involved in a lot of these cases, and a typical team will be local lawyers from the country where the harm takes place, working in tandem with lawyers from the country where the multinational is domiciled. And the third partner in these cases is typically a local NGO, which is a critical partner to liaise with the lawyers, help obtain information, communicate with the clients, and so on. Foreign lawyers and local lawyers, for that matter, typically will not do cases against multinationals seeking compensation for harms, except on a no-win, no-fee basis. These cases are simply too expensive to be done pro bono or for free. The way the lawyers are paid, if the case is successful, they're not paid if the case is not successful, is typically by application of the loser pays rule, which outside of the US is the general rule. Whoever loses the case has to pay the other side's fees. And that's a way of that mechanism allows the lawyers to not dig into the client's recovery when they are paid. And a small but growing number of firms are willing to do these cases in Europe and elsewhere. Another very critical issue is, even aside from the lawyer's time, what about expenses, out-of-pocket expenses in the cases? Money that needs to be paid for expert witnesses, perhaps, travel, filing fees, things of that type. Typically, lawyers will require that money not come from them, but from some other source, and for this reason, EDLC created a grant program for expenses in these cases. Often, along with other funders, if we're able, we provide expense money in these cases. Before I turn to a couple of examples of these cases, to summarize the disadvantages, I've mentioned the two main ones, inconvenient forum and parent subsidiary question. Other issues include, is the case big enough from a financial standpoint? Are the damages big enough to make the case economically viable, worth pursuing? The remedy is limited, it's money. Is that really what the clients want? If there's something else they want, they can't get it, most likely, in a transnational case. The cases are expensive, they're logistically difficult. It's hard to pursue litigation in one country when the facts and the witnesses come from another country. And a final obstacle sometimes is an occasional requirement that if you represent a foreign victim, that victim must post a bond with the court in the event that they lose the case, and the other side, as prevailing party, needs a pot of money from which to recover, and this requirement can signal the end of a case even before it's brought. So just to talk in the last few minutes here about some cases we've been involved in, what we've learned from them. The first one I'll talk about is the Monterrico case from Peru, in which about 30 individuals were claimed that they had been kidnapped and tortured. These were opponents of a mine. They were at a protest in Peru, and the company was English. And of course, the company and the government denied these charges. We received photographs documenting the torture. And after a long, difficult fight, the case settled. The clients basically received exactly what they asked for, and they were represented in that case in England, in London, by Lee Day, the leading firm in the world doing these types of cases, at least in the UK where they practice. Some things that worked well in that case or led to the case's success. We had very strong evidence, not just the photographs, but Lee Day paid for a researcher on the ground for a year who developed evidence of the wrongs as well as additional human rights violations by the company. Even with these strong facts, the company fought hard, but in the end, on the eve of trial, proposed settlement with the victims fully compensated. However, what the case didn't achieve and couldn't achieve was the goal of trying to stop the mine from going ahead for the reasons I mentioned before. The second case I'd like to discuss is really kind of a carbon copy of the first one, also in England, also from Peru. This time the mining company is Xstrata, a company well known to many of you here in the Philippines. Again, charges of torture and other human rights violations of opponents of the mine who were held at a facility, police facility on mining property. The case is not set for trial, should be next year, hopefully. What have we learned so far in this case? I would say two things. First, the bigger the company, the bigger the fight. They're arguing, Xstrata is arguing a lot of additional claims that were not argued by Monterrico in the earlier case. And perhaps more importantly, the bigger the company, the harder it is to show actual involvement or control by the parent company, wherever it's headquartered, of the many arms, the many tentacles of the company around the world. In the Monterrico case, the mine in Peru was their sole asset. Not surprisingly, they were very involved in its management, including security issues and so on. Much more difficult to prove when it comes to a company with dozens of operations around the world. And in the field of environmental and health harms, our largest case is one pending in Sweden, where mining waste was shipped to Chile many years ago containing arsenic, poisoned a city. Over 800 victims are bringing a case in Sweden, represented by lawyers we found there. In this case, one of the things we're facing, and it's common in all environmental and health harm cases, is the difficulty of establishing scientific proof and causation. And as a result, because physicians typically can't and won't say that a particular individual suffers from a particular illness because of a particular toxin from a mining company, it just can't be shown. Instead, we're asking for the same amount of damages for each victim, and we're basing our claims not on individual health complaints, but the fact that each and every one of them has arsenic test levels significantly above permissible levels. And we're taking that approach in some other cases as well. There are a number of other cases I could discuss, but I'm running low on time. We have also supported, though, several cases brought in country. One in Brazil we're working on right now involving iron ore air pollution from smelters. Another one in India involving asbestosis from a mine that was never remediated. And in those cases, we're working with local lawyers who are supporting in a number of ways that I've described. So to wrap up, a few important points. I would urge you to always consider the domestic approach first, especially if you're trying to stop a project. See whether your courts are a reasonable place to go to bring these cases. It's a lot easier, less expensive. However, when that's not possible and it's a transnational company, by all means, consider that option. Second point, transnational cases require a lot of work and certain factors must be present. I've talked about those factors earlier, most important being where is the parent company domiciled, what's the viability of the case legally, factually, economically, and do we have strong local partners and especially an NGO and capable lawyers to work on the case. Going forward, we and other groups are happy to evaluate and discuss strategies in these cases with you. The fact that the Philippines legal system is a common law system conducted in English makes it much easier for us to find lawyers from the US and Europe to work on these cases. I'm sorry I couldn't be with you today, but thank you for having me by video, and I look forward very much to hearing from you. EDLC, again, .org is our website, and I can be reached at Lewis, Lewis, or at info, either one, at edlc.org. Thanks so much. Bye.